Do you believe the international community has the power to change what happened on November 20th? Type yes or no in the comments section. Let this channel know where you stand. And while you are doing that, subscribe, turn on the notification bell, and stay with me to the very end, because what I am about to tell you today is bigger than one man, bigger than one judge, and bigger than one country. The story you have been seeing online about the ICC summoning Justice Omotosho is not the full picture. Today I am going to give you the real picture, not the noise, the facts behind the noise. And trust me, the facts are more powerful than the headline. On November 20th, 2025, Justice James Omotosho of the Federal High Court in Abuja sentenced Nnamdi Kanu to life imprisonment on terrorism charges. 7 counts. Convicted on all 7. The judge ruled that the prosecution's case stood unchallenged after Kanu was removed from the courtroom for what the court described as persistent, unruly behavior. No defense was entered, no final address from Kanu himself, and just like that, life imprisonment. The heaviest sentence, short of death. The next day he was moved to Sokoto, not Kuj, not Kefi, not any facility close to Abuja. Sokoto, one of the farthest corners of Nigeria from the southeast. His lawyers were not informed in advance. His family was far. His legal team immediately raised an alarm. Barrister Aloya Jimaka confirmed the transfer publicly and expressed serious concern. The application to move Kanu back closer to Abuja, where he can properly pursue his appeal, has already been filed in court. As of the last update, that matter was adjourned, and the Correctional Service was directed to be put on notice. Now here is where the online story begins. After all of this happened, multiple claims began circulating that the ICC summoned Omotosho, that the ICPC arrested him, that an assassination attempt was made on his life. Each one of these claims was investigated and denied. The Federal High Court itself issued a statement calling the assassination story completely false. The ICPC released an official statement saying it has neither arrested nor invited Justice Omotosho, and that it has no mandate to probe serving judicial officers. And fact-checkers confirmed that no credible platform reported any ICC summons against Omotosho. So why are we talking about this? Because inside the noise, there is real fire. IPOB formally wrote to the ICC, not a rumor, not a social media post, a formal call published through their spokesperson Emma Powerful, demanding that the ICC and the Nigerian Judicial Council open an investigation into Justice Omotosho. Their grounds were serious. They alleged that during the trial, Nnamdi Kanu repeatedly asked the court to show him the written law under which he was being charged. According to IPOB, that law was never read aloud in court. Their position is that the life sentence was built on a law they describe as nullified and foreign to the Nigerian constitution. Whether that argument succeeds legally is a different question, but the formal demand to an international body is now on record. There is also the matter of Kenya. On June 24, 2025, a Kenyan High Court ruled that the 2021 abduction and transfer of Nnamdi Kanu from Kenya to Nigeria were unlawful and constituted a violation of his fundamental human rights. That ruling did not happen in Aba. It did not happen in Enugu. It happened in a foreign court with no political reason to favor Kanu. That ruling now sits in the legal background of this entire case. It is a documented international legal finding that the process which brought Kanu back to Nigeria in the first place was irregular. That fact does not disappear because a Nigerian court later convicted him. This is the angle that matters, not whether the ICC sent a letter last week. The question is whether the foundation of this entire case can survive international legal scrutiny, because every layer of this prosecution, from the rendition in 2021 to the court proceedings, to the judgment delivered in Kanu's absence, to the immediate transfer to Sokoto, has been questioned, not just by IPOB, not just by supporters, by legal minds, by human rights observers, by a sitting Kenyan court. What the ICC actually does and does not do is important to understand. The International Criminal Court does not rush. It does not respond to social media petitions in 1 week. It moves through documented processes, formal submissions, and established legal channels. When a petition reaches it, it considers whether the situation falls within its jurisdiction, whether national remedies have been exhausted, and whether there is a reasonable basis to proceed. None of that happens overnight. But the door that was opened by IPOB's formal submission is now open, and every action taken around this case from this point forward adds to the picture that body will eventually consider. For Nigeria, this is the uncomfortable reality. The world is not looking at whether Nigerians like Nnamdi Kanu or not. The world is looking at process. Was he brought to Nigeria through lawful means? Kenya says no. Was he allowed to fully present his defense? The record shows he was removed from the courtroom before judgment. Was the transfer to Sokoto justified? No official explanation has been given that satisfies that question. Strong institutions answer these questions clearly. They do not wait for international pressure before providing explanations. They do not let a silence grow into a scandal. Every day that passes without a clear official response to the Kenyan court ruling, without a clear reason for the Sokoto transfer, without a transparent answer about which law was read in that courtroom, is a day this story grows larger, not smaller. Nnamdi Kanu's appeal is still alive. The Court of Appeal has not spoken. The Supreme Court has not spoken. And beyond Nigerian courts, the international channel opened by IPOB's petition remains open. Whatever you think of the man, whatever you think of his movement, the process that produced this life sentence is now being examined from multiple directions at the same time. That is not an opinion. That is the current state of this case. Nigeria has always said it respects the rule of law. This moment is the test, not the loudest test, not the most dramatic one, the quiet, document-level, record-by-record test. And in that kind of test, silence is not a strategy, transparency is. This story is not over. It has barely entered its next phase. And however it ends, it will not end quietly. Drop your comment, share this video, and stay close to this channel because as this case moves, we will move with it.